Good afternoon.
Hello, good afternoon.
Good afternoon,
Good
everyone.
Please, Professor. Yes.
So good afternoon, everyone. For the benefit of the court reporters, as you know, in every case, there will be somebody who records the session and produce a transcript of that. I welcome you to this session, this hearing in the matter of ICC case number Moot 100/MM. That's a dispute between a Sensor and Visionic. Sensor X and Visionic Ltd. I'm here with my co-arbitrators. Of course, I'm not Giovanna Nelli. Have transformed myself since the beginning of the case to Lucas Mistelis. I'm professor at Queen Mary and a partner at Clyde & Co. And I'm here joined by my two co-arbitrators who I would like to have them introduce themselves. To the north of your where you are, Michelle.
Yes, good afternoon, everyone. I'm Michelle Grando. I'm one of the arbitrators in this matter, as you're familiar with. I'm a counsel at White & Case, sitting in Washington, D.C. and today, but also sharing time with New York. And I look forward to hearing the submissions of both parties.
Good afternoon. My name is Laura Guicci. I'm a senior associate here at Souto Correa. I'm based in São Paulo. And thank you very much for participating in our Pre-Moot, and I wish good luck to both teams.
So, as you very well know, I will take a sort of appearances who is here for the claimant.
Good afternoon, members of this tribunal, and good evening, Professor. I'm Fernando Mentoni. I'm going to represent claimant on the merits of this dispute alongside my co-counsel, Wilson Araújo. They will represent on the procedure issues.
Yes, so if you don't mind, just so I get your names correctly. Fernando
Mentone and Wilson Araújo.
Okay. Thank you. And for the respondents?
Good afternoon, members of the tribunal, counsel for claimants. My name is João Victor Sampaio. I will be speaking for respondent on procedure, and my co-counsel Christian Franz will be speaking for the merits.
Okay. Thank you very much. So we talked last time at the procedural order back in October 2023. I wonder whether you have had an opportunity to discuss with each other how you want to allocate the time we have at our disposal today.
The parties have not had the opportunity to talk about it and discuss the time allocation and order, but claimant requests that would be concerning the time, 14 minutes for each counsel to make its submissions, saved 1 minute for rebuttal and another minute for surrebuttal. And when it comes to the order of the procedure, claimant requests that on the procedure issues, claimant to go first, followed by respondent. And on the merits, respondent to go first, followed by claimant. The reasoning for this is that on the jurisdictional issues, it is claimant who is bringing the possibility to add a new claim or consolidate the proceedings. So it would be more beneficial for both this tribunal and the parties if claimant could raise its allegations and respondent can answer in the same grounds without anticipating the claim. And when it comes to the merits, it is a premise in the present case that claimant delivered goods and did not receive the payment, and respondent is raising an exemption for its obligation to pay. So it will be also more beneficial if respondents to go first and raise the grounds for its exemption, and claimant can answer on the merits. By doing this, both parties will have the right to have a responsive speech as well.
Is that agreeable to the respondents? We have a counter proposal.
Mr. Presiding Arbitrator, I just believe there is an echo from the counterparty's side. If it could be just close the microphone, please. Well, Respondent agrees with the proposal on procedure, beginning with claimant on procedure, because indeed it was claimant who presented a request for a new claim. However, respondent does not believe that it would be reasonable to begin the merits with respondent, because the request for payment in the present case is being made by claimant and not by respondent. The exemption is one of the defenses that will be used.
I see we don't have an agreement, so we might have to make a decision very quickly. But also, I'd like to hear both sides about the time allocation. So, do you agree with the proposal of the claimant?
Yes, in regards to the time allocation, we agree. Yes.
And that's a question for both sides. Is the 40 minutes equally split between the two pleaders, or a topic might take more or less?
Would be 14 minutes for each counsel to make its submission, and that would be enough. Save it 1 minute for rebuttal and another minute for surrebuttal.
Okay. And is that acceptable to the respondent in that sense?
Yes, Mr. Presiding Arbitrator.
Okay. So obviously we haven't had the chance to deliberate on the order of proceedings. I would, assuming we have now the time sort of to turn to next in the room next to my co-arbitrators, I would be rather prepared to go with the respondent's proposal and have the claimant make the entire submission and the respondent make the entire submission. If nothing else, I know that very often in Vienna, in Windebonne rather, people like respondents to start part of the argument, but in real life terms, in most cases, the claimant has to present the case. So let's go for that, and unless there are very sort of violent objections to that, is that acceptable to the claimant?
Yes.
Okay, thank you. So I assume you're doing some part of the timekeeping, and the way the tribunal has discussed the case ahead of the hearing is that there will be questions as you present. So unless the questions are particularly disruptive, we will assume that this is within the 40 minutes time, but we might extend the time as necessary to allow you to present your case. Very good. So Mr. Mentone, are you then starting, or is Mr. Araujo?
I will be starting, Mr. Presiding Arbitrator,
Okay.
on the procedure issues of the case.
Thank you.
Claimant at present, and first of all, once again, good afternoon, Mr. Presiding Arbitrator, members of this arbitral tribunal. At present, claimant has two main submissions concerning the procedural issues of the present case. First, that this tribunal can and should admit the new claim raised by it. And second, that this tribunal can and should consolidate proceedings in case the new claim is raised on a separate arbitration proceeding. The case at hand involves a framework agreement signed between the parties. This framework agreement originated two main purchase orders, which, by their part, originated two distinct yet related disputes. In short, claimant was a victim of a cyber attack, and the consequences of this were two. First, hackers sent respondent a fraudulent email, and respondent was led to pay the first purchase order to the wrong bank account. Second, claimant's systems were shut down, and it was unable to receive an alleged notice of defect sent by respondent concerning the second purchase order. While the first claim was raised in claimant's request for arbitration, the new claim was raised shortly after the signing of the terms of reference. Nonetheless, claimant requests this tribunal to hear both claims together. And this leads me to claimant's first submission, which is twofold. First, this tribunal does have jurisdiction over the new claim. Second, the requirements set forth by Article 23.4 of the ICC rules are met for the admission of the new claim. On to the first point of claimant's first submission, it is relevant to emphasize that The jurisdiction of an arbitral tribunal is determined by and limited by the arbitration agreement signed by the parties. Now, let claimant be the first to recognize that in its request for arbitration, it has transcribed the arbitration agreement of the first purchase order. Nonetheless, in the same request for arbitration, it has also referenced the arbitration agreement of the framework agreement. In this sense, the present arbitration is a multi-contract arbitration pursuant to Article 9 of the ICC rules. And if I may quote from Article 9 of the ICC rules, subject to the provisions of Article 6.3, 6.7, and 23.4, claimants arising out of or in connection with more than one contract may be made in a single arbitration, irrespective of whether such claims are made under one or more than one arbitration agreement under the rules. This being said, claimant submits that this tribunal should consider the arbitration agreement of the framework agreement to rule its jurisdiction. If this tribunal may please follow me to page 11 of the case records, and please do tell me when you arrive there.
Thank you.
Before you is the framework agreement signed between the parties. Article 41 is the dispute resolution clause, and in the second point, the third line after the comma starting with it being, I quote, it being the intention of the parties that this is a broad form arbitration agreement designed to encompass all possible disputes arising in connection with the present agreement and the contracts concluded thereunder. Members of this tribunal, this provision establishes both parties' intent to have all disputes relating to the contracts concluded under the framework agreement to be resolved by one arbitral tribunal together. This is sufficient for this tribunal to rule its jurisdiction over all the related claims. It is exactly what teaches, for example, Professors Fouchard, Gallard, and Goldman. In this sense, as this tribunal has jurisdiction both over the first claim and the new claim, claimant moves on to the requirements. Now, claimant's second point of its first submission, the requirements set forth by Article 23.4 are met. Now, such provision establishes that after the parties have signed the terms of reference, no new claims shall be made unless the arbitral tribunal authorized such. To authorize the new claim, the tribunal must consider three relevant circumstances, three requirements. First, the nature of the claims. Second, the stage of the arbitration. And third, other relevant circumstances. Concerning the nature of the claims, the Secretariat's Guide on ICC Arbitration provides that two claims have the same nature if they concern to similar questions of fact and law. In the present case, we have two disputes that arise out of purchase orders made under the same framework agreement. But that is not the only overlapping issue at present. Both disputes concern to the amendment requirements set forth by Article 40 of the framework agreement. Both disputes concern to whether or not claimant should bear the consequences of the cyber attack. That is to say that the addition of the new claim would lead this tribunal to rule on overlapping issues of fact and law, circumstance which claimant understands sufficient to a point that both disputes have the same nature. This is, in fact, the understanding of ICC case number 5989, in which the arbitral tribunal understood that common questions of fact and law and a sufficient link between both disputes are sufficient to admit the new claim.
If I may sort of, as in a set of it, sort of with the view of, I understand your argument on the can, but the question is whether they should. And I think you're correctly stating both Article 41 of the framework agreement and indeed the ICC rules. But the question is whether, so in which cases you refer particularly to 23 or 4 of the ICC rules. But the question is, the critical question for every tribunal, for us as well, is the should. Do we have enough similarity, not of the nature of the claim, but of the facts, the legal questions, or would that sort of consolidation, if you wish, or admission of the new claim make the process much slower? As you know, efficiency is one of the concerns of all tribunals these days.
I understand your question correctly, Ms. Arbitrator. It concerns to if
The should
what
rather than the could,
the
yes.
should rather than the could. Perfect. It is claimant's contention that the should is expressed precisely by Article 23.4 of the ICC rules, while the could is relating the jurisdiction. That was the first point of the claimant's first submission. Therefore, the requirements set forth in Article 23.4 are relevant to decide whether the tribunal should or not admit the new claim. And as the first requirement is fulfilled, claimant moves to the second, the stage. Please, Madam Arbitrator.
Excuse me, counsel, if I may ask a follow-up question. This arbitral tribunal here shall weigh efficiency gains and avoid contradictions in the decisions of the two claims. Like, are the two claims independent, or depending on the decision that the arbitral tribunal reach on one claim, there is a risk of a contradictory decision in another claim? Is it something that you were considering to request that both claims be decided by the same arbitral tribunal?
Yes, Madam Arbitrator. In fact, it's claimant's submission that if these two disputes be heard separately, there is a risk of conflicting decisions precisely because there are overlapping issues of fact in law that can be decided differently in two different arbitral tribunals.
And could you please develop more on the issues that could on the issues of fact and law that could lead to contradictory decisions, please?
Perfect. Concerning Article 40 of the framework agreement, if the tribunal is still with me in page 11 of the case records, Article 40, amendment. I quote, "No amendment or waiver of any provision of this agreement, including this article, shall be valid unless the same is in writing and signed by the parties." A main concern of the first claim is regarding the fraudulent email sent by respondent, and if whether the parties could have waived Article 7 of the framework agreement concerning the bank in which the deposit for the first purchase order must have had been effective advice. Regarding the new claim, this article will be addressed as respondent did not properly send the notice of defect regarding the second purchase order. Therefore, in both cases, the tribunal would analyze and address whether respondent, in fact, honored Article 40, the amendments required. Therefore, both claims would have conflicting decisions. And concerning the second requirement, stage of the arbitration. According to Handbook on ICC arbitration, there would be no reason not to admit a new claim if the admission of the new claim did not imply a delay in the procedural timetable already established by the parties. This tribunal may please follow me to page 65 of the case records, and please do tell me when you're there. What this tribunal has before it is the procedural order number 2 rendered by this tribunal. On clarification number 34, the question is, did the parties agree on a procedural timetable in connection with their terms of reference? The answer, yes. For the original claims under purchase order number 9601, the procedural timetable has not been altered. Members of this tribunal, that is to say that the admission of the new claim would mean that the merits of the new claim would only be addressed on a second phase of the proceeding, and that this tribunal would be able to quickly and promptly resolve the first claim on the first stage. This is to say that the inclusion of the new claim means that the parties would enjoy all the benefits from having two related disputes be heard by the one tribunal while suffering none of the procedural drawbacks. As the requirements set forth in Article 23.4 are met, the inclusion of the new claim is a favorable outcome. Now, even if the tribunal understands that that is not the case, if the new claim is raised on a separate arbitration proceeding, this tribunal has the power to consolidate, and it should consolidate. Moving to the first point of claimant's second submission, this tribunal has the power to consolidate proceedings. It must be taken into account that Article 10 of the ICC rules have a consolidation provision that vests the ICC court the power to consolidate. However, under the Article 41 of the framework agreement signed between the parties have vested this tribunal with the power to consolidate. That is to say that the bodies have completely derogated from Article 10 of the ICC rules. And this is, members of the tribunal, by no means an exceptional circumstance. In fact, in ICC case 16982, the bodies have also validly derogated from Article 10 of the ICC rules. The tribunal in that case ordered a consolidation order, and the Secretariat recognized it and enforced it, consolidating proceedings. Therefore, as this tribunal has the power to consolidate.
Excuse me, Counsel. In this case that you just mentioned, the parties have expressly derogated from Article 10.
Yes, Madam Arbitrator, they had signed a contract validly and derogating completely from Article 10. And
Only Article 10, or did they derogate from other rules?
This information, as it is an extract, this information is not provided. However, the relevant information here is that the parties have validly derogated from Article 10 of the ICC rules. And that being said, the requirements set by the parties are also fulfilled, that being mainly the risk of conflicting awards, as already detailed by the claimant. In fact, both cases would have necessarily to rule on whether if respondent has effectively honored the amendment requirements set forth by Article 40, as well as if claimant bears or not the risk of conflicting decisions. In fact, as Professor Pierre Meyer has established, the rationale of the decision, if they are conflicting, there is one possibility of conflicting awards. As it is expressed in Article 41, this was a preoccupation of the parties. And therefore, as the requirements are fulfilled, this tribunal should admit the new claim and hear their claims together. I reiterate claimant submissions, and I thank this tribunal for its attention.
So thank you. I wonder whether we should perhaps now proceed to hear the respondents on the same matter before we continue with the further argument. I think that would allow the tribunal to sort of address the questions to both sides. So would you be ready to go ahead now, the respondent? On the could and the should, or could not and should not.
Mr. Presiding Arbitrator, only to confirm, so the question here now is whether the arbitral tribunal could or should determine consolidation. Is that it?
Correct.
Okay. Mr. Presiding Arbitrator, the ICC rules, and just a question, how much time do I have to answer the question?
I think we have allotted to the claimants just over 15 minutes. I think that's around the same time with the questions, of course.
Okay.
Just for clarification, I think it wouldn't be focused only on consolidation, but whether we can admit the claim as part of the terms of reference as well.
Yes.
All right. So, members of the tribunal, opposing counsel, once again, good afternoon. I would like to structure my arguments mirroring my opposing counsel's arguments in these proceedings. For the next minutes, I will be addressing the procedural matters of this case. Members of the tribunal, let me clarify the circumstances of the present dispute. After claimant has failed to comply with its obligations of disclosure about the cyber attack that happened in 2022, claimant now intends to present a new claim which is entirely related to the matter of non-conformity of goods and completely out of the scope of the present arbitration. Now, in regards to these issues, I will structure my arguments in two parts. Firstly, I will address why this arbitral tribunal should deny the addition of the new claim. And secondly, I will discuss why this arbitral tribunal cannot and should not determine the consolidation of these proceedings. Now, firstly, addressing the question that was made, respondent does not contest the power or the jurisdiction of this tribunal to accept new claims into these proceedings. Indeed, that was mentioned by opposing counsel, and indeed, respondent agrees. However, even though opposing counsel mentioned Article 9 and Article 23, Paragraph 4 of the ICC rules, the requirements set forth in order for the new claim to be added in these proceedings are actually not fulfilled. But firstly, I would like to point to the intention of the parties, which was an important issue raised by opposing counsel. In order to demonstrate that the parties intended different arbitrations, I would like to request this arbitral tribunal to follow me to page 46 of the case files. Is the tribunal with me? Thank you. Members of the tribunal, this is claimant's own request for the addition of a new claim. Now, I'd like to ask the tribunal to look into paragraph 3, and here I quote, "Following intensive negotiations between the parties, starting at the end of 2021, it was agreed that respondent could submit an additional order for the censor L1, which would be covered by the framework agreement in all aspects not specifically regulated differently by the parties." End of quote. Now, in the present case, members of the tribunal, we have different arbitration clauses inserted in each purchase order, different from that of the framework agreement also. So claimant took this arbitral tribunal to the arbitration clause of the framework agreement, despite the fact that the parties clearly put different arbitration clause in each purchase order, having the intention of different arbitrations for each of the claims that could arise from these purchase orders. But not only that, even though opposing counsel has correctly mentioned Article 23, paragraph 4, the requirements are not met. For instance, if you look into the nature of... Yes, Madam Arbitrator.
If I may, I don't know if somebody else had a question as well. It's probably me then. Staying with the arbitration agreements, would you say that these arbitration agreements are significantly different, the framework agreement and the agreement concerning purchase order A15604? Don't you think that they have that they are compatible and could be sort of read together and wouldn't therefore necessarily be a different regulation, but sort of like complementary agreements instead of different and contradictory?
Well, thank you for the question, Madam Arbitrator. Now, respondents would firstly like to state that respondent does not submit that the clauses are incompatible. The clauses are compatible. However, indeed, there are differences in these arbitration clauses that demonstrate the intention of the parties of have different arbitrations. And once the parties themselves have established that specific provisions would prevail over the general provisions, then the mere fact that the parties chose new arbitration clauses to each purchase order is a demonstration that they derogated from the arbitration clause of the framework agreement, which takes me also to the requirements in order for the tribunal to accept a new claim. Members of the tribunal, the first issue to be considered by this arbitral tribunal, as correctly mentioned by opposing counsel, is the nature of the claims. However, if we look into the nature in the present case, while in the first claim we would be discussing whether a claimant had a duty of disclosure in regards to the cyber attack of 2022, under the second claim, we are discussing whether the contractual obligations were fulfilled by claimants in the censors that were sent to claimant to respondent. We are discussing, therefore, duty of disclosure in one claim and non-conformity of goods in the other claim. Now, Professor Christopher Imhoos, for instance, who worked as a legal counsel for the ICC and was also a professor at law at the University of Geneva, has stated in his book, ICC Arbitration in Practice, that if the new claims deals with quite different matters from those mentioned in the terms of reference and are unrelated to the initial request for arbitration, they should not be accepted by the arbitral tribunal. And a similar conclusion can be found, for instance, in the ICC case 2910, in which the arbitral tribunal recognized that a new claim was not exactly connected to the first arbitration and to the first claim, which was why the tribunal, in a decision from 2017, decided that that new claim should not be added. Now, if this tribunal...
Excuse me, counsel, if I may, could you please give us more information about this case that you just mentioned? Which was the difference of the claims in the ICC award?
Thank you for the question, Madam Arbitrator. Now, in that case, what we had was that after the terms of reference were signed, a new claim was presented by claimants related to other contractual obligations which were not related to the same contract and to the same claims that were being discussed under the first arbitration. So when taking into consideration these issues, the arbitral tribunal correctly asserted that there would be a disruption of the proceedings by accepting those claims, not only in that stage of the proceedings, but also unconnected from the claims that were presented in the first arbitration. But this is not...
Yes, counsel, but isn't this case different from the case at hand? Because if I understood correctly, in the ICC award that you just mentioned, the claims were related to different contracts, and here we have the same agreement, the same framework agreement being discussed between the parties.
Madam Arbitrator, Respondent respectfully disagrees, because in that case, there was also a main document being discussed and several accessory contracts, which is exactly the same situation as in the present case. In our present case, even though we have a framework agreement, we have different purchase orders, which are accessory contracts, with different arbitration clauses in which different claims are arising. So we have indeed a common discussion in these claims. However, also if we look into other factors in the present case, this tribunal would reach the same conclusion that the new claim should not be added. Now, Respondent does not oppose to the idea that the stage of the proceedings is still early in the present case. However, if we look into the present proceedings, we can see that 8 months have passed since the commencement of this arbitration, and that this arbitration is sufficiently developed to commence the hearings on the merits of this dispute. Therefore, this tribunal has two paths to choose. It can either deny the addition of this new claim and initiate the quick resolution of this dispute, or accept a whole new set of facts and legal provisions completely related to the issue of nonconformity, and not only raise the complexity of the present arbitration, but delay these proceedings, which is why this claim should not be added. And if we look into the other...
Excuse me, counsel, but just in terms of the efficiency of the proceedings, what would you say if the tribunal would deal with the first claim regarding purchase order 9601 and come to a partial award that could then be already enforced by whichever party is concerned, and then remaining only the question of the specific facts of purchase order 15604?
Madam Arbitrator. However, that should not be accepted for two reasons. First, because it is not reasonable to expect that bringing the new claim into these proceedings would not delay the proceedings, even if they were discussed in separate instances. For instance, because the procedural matters of the second claim would still have to be discussed by the arbitral tribunal, while the merits of the first claim are being discussed. And secondly, because that would preclude our client from nominating a specific arbitrator to deal with the issues under the second claim. Now, Mr. Victor Claimant, who was nominated as an arbitrator in the present dispute, was nominated specifically to address the matters of the cyber attack. This means that our client, Respondent, intends to nominate a specific arbitrator to deal with these issues, and our rights would be harmed by accepting the new claim into these proceedings. Now, there would also be no noticeable savings, members of the tribunal, by accepting the new claim. It would actually raise the complexity and the cost of the present arbitration, and this tribunal may even need to nominate an expert to assess the non-conformity of goods under the second claim. Now, moving forward to the second part of my arguments, members of the tribunal, which relate to the consolidation of the proceedings, I would like to address the questions that were raised, that was, raised by Mr. Presiding Arbitrator in regard to whether there could and should be a determination of consolidation by this arbitral tribunal. Firstly, I would like to mention that according to Article 1 of the ICC rules, the administrative powers are exclusive powers of the ICC courts. And members of the tribunal, Article 19 is clear in establishing that the rules apply, and where the rules are silent, then the parties could agree on different provisions. According to Professor Bernard Hanotio, in his book about complex arbitrations, multi-party and multi-contract arbitrations, he states that no power is conferred to the ICC court to the arbitral tribunal in order to determine consolidation under the ICC rules. Now, opposing counsel has mentioned Professor Pierre Meyer in these proceedings to sustain its arguments that consolidation should be applied because of the risk of a conflicting decision. However, Professor Pierre Meyer also states that there would only be a conflicting decision in regards to monetary claims if these claims arise from the same cause, which is not the present case, members of the tribunal, because one issue is the non-conformity of goods, the other is a cyber attack and a duty to inform. Therefore, it is claimant submission, that respondent submission, that these requirements are not fulfilled, as well as none of the requirements of Article 10 of the ICC rules, which is why respondent submits to this arbitral tribunal that any request for a new claim should be refused, and also that consolidation should not be granted. Thank you.
Yes, before we give the right to the claimants for a rebuttal, I would like to explore with you one question. I mean, you indicated that one of your particular concerns is the right to appoint an arbitrator who is specifically suitable, or sort of expert in the subject matter. And I wonder whether that matter can be resolved by an appointment, if need be, of an appropriate expert, either by the tribunal or by the parties, to advise on the cyber attack issue.
Mr. Presiding Arbitrator, it is respondent's contention that that will not be enough. Even though an expert may assess the issue, an expert will not decide on the issue. And the constitution of an arbitral tribunal is one of the most important rights in international arbitration.
And that's exactly why I'm making the point, because I think I was looking in a particular context of a case recently that 60% of arbitrators are not qualified in the law they apply in a particular arbitration. Therefore, the duty of presenting the case lies ultimately with the counsel, and the counsel can use any expertise. The expert doesn't decide, but advises the tribunal as a different kind of counsel. Thank you. So, the claimants, do you have any point of rebuttal on the arguments presented by the respondent?
Members of this tribunal, respondent misquotes Professor Meyer-Pierre. Claimant states, and claimant takes the opportunity to quote Professor Pierre in its article, Conflicting Decisions in International Commercial Arbitration, page 416. I quote, conflicting awards can exist in each time it has not been possible to bring closely related claims before a single arbitral tribunal. Both claims are related, be by the framework agreement or by the common questions of fact and law. There is a risk of conflicting decisions if both claims are heard separately. Therefore, they should be heard together by this tribunal. Being that, in fact, claimant admits that the clauses are compatible, therefore, there will be no risk in hearing both claims in conjunction. Thank you very much.
Thank you. I'm not sure whether you want to have a further rebuttal on Pierre Mayer's article or...
Thank you, Mr. Presiding Arbitrator. Now, there is no misquote in the present case. Firstly, because there are no common questions in our case. We are discussing the non-conformity of goods in one claim and the duty of disclosure in the other. And secondly, what Professor Pierre Meyer mentioned is that the problems would have to arise, here I quote, for the same cause, end of quote, and they are not provoked by the same cause in our present case. And that is paragraph 6 of the page 409, which was mentioned by opposing counsel.
Okay. So I think that brings us quite, thank you very much for your submissions on these issues, on the admissibility of the new claim and the consolidation, which interestingly enough is presented almost sort of as one or two distinct issues. Would the claimants be prepared to, ready to proceed with the arguments?
Good afternoon once again, members of this tribunal. I'm going to address claimant submissions on the merits of this case. We're here before this tribunal today because, as already stated, the parties signed a framework agreement in 2019 to regulate the supply of goods from claimant to respondent. In 2022, respondent submitted a purchase order for the acquisition of sensors, which were promptly delivered by claimant and accepted by respondent. On that year, claimant was a victim of a cyber attack, and because of this cyber attack and the encryption of its systems, it took months to realize that the missing payments from respondent that had not paid to claimant's bank account for the acquired goods. Now, claimant requests that its right to be paid be exercised by this tribunal. So to better address my submissions, I will address first that claimant is fully entitled of the payment concerning the accepted goods, and second, respondent cannot reduce its payment obligation. Moving to my first submission, under the CISG, that is the only applicable law to our present case, the seller has the duty to deliver conforming goods in the time and place provided in the contract. As for the buyer, it is required to pay for the goods in accordance with the formalities stipulated under the contract and to take delivery of the goods. Claimant fulfilled its obligations to deliver the goods and were accepted by respondent, but never received any compensation for the delivered goods. Respondent is trying to rely on an exemption for performance under Article 80 of the CISG. Article 80 of the CISG provides that, due to an act or omission from one party, the other party is exempted of performance if it was caused by such act and omission. On commentating Article 80 of the CISG, Professor Brunner quotes two premises to apply these exemptions. They are cumulative. The first, there must have a causation. And the second, the counterparty, the non-performing party, must be expected to have overcome by itself the first party's conduct. Moving to the first requirement, the causation, there was no causation in claimant's conduct. But first we need to take a step back and understand which duty or obligation were breached by claimant's conduct. My opposing counsel already brought for this tribunal that claimant would be under a duty to inform, but claimant was not under a duty to inform. Under the CISG, it is provided expressly on Articles 40 and 42 that the seller is required to inform when it comes to the conformity of the goods or third-party claims, also related to the goods. Respondent might try to imply a duty to disclose from a duty to cooperate that underlines Article 80, but that shall not proceed. Also, under Article 80 and this duty to cooperate, the parties are required to assist when it comes to information or duties that are related to the fulfillment of the contract. This
Councillor,
because...
if I may intercept here, because I think you are bringing actually together a number of different issues, because you bring a duty of disclosure, you bring a duty of cooperation, a duty of cooperation, a duty of notifying the other side. Isn't sort of both the letter and the spirit of the CISG, that the contracting parties have to stay in touch and communicate any efficiencies or defects as soon as practicable. And that the lack of such exercise might have the consequence that the party may not rely on the CISG for a particular claim.
The arbitrator, if I understood your question correctly, is if under the CISG, the parties are required to inform relevant information for the performance.
Yes.
Yes, Mr. Arbitrator, it is correct, but this is not our present case. Claimant does not contest that if it is related to the performance and we must take into account the time of the information and what is relevant on that time, claimant was not under a duty to inform even in that situation. The cyber attack appeared in January of 2022, and claimant at that time, realizing about the cyber attack, first took an evaluation, and second, hired the top leading cybersecurity firm in its country to have another evaluation and to eliminate all the risks. And to demonstrate that, I'd like to guide this tribunal to page 64 of the case files.
So you will not give any relevance to Article 39 or the sort of the equivalent of Article 39, because you seem to be only referring to Article 80.
Mr. Arbitrator, I brought Article 80 because respondent is trying to rely on an exemption that would be under Article 80, but even under Article 39, 40, or 42 of the CISG that provides expresses duties to inform, claimant will still not needed to inform on our present case. And when it comes to material information, at the time that claimant knew, could not connect to the performance or to respondent. And this information is provided on qualification 25. We are looking at the procedural order number 2, and I quote on number 25, why was the cyber attack of January 2022 initially categorized as being of minor relevance? And in the same line where it begins with first, I quote, first, it appeared that neither direct competitors, nor foreign state entities, were behind the attack. Second, the malware, as at least seems so, was quickly detected and neutralized. And third, the malware did not appear to have infiltrated parts of the systems that store sensitive personal data or any trade secrets. So claimant was facing a situation that had any connection to the contract, the performance, or respondent. So here we cannot extract a duty to inform general information that would apply in our present case. My opposing counsel may also bring the UNIDROIT principles to infer a duty to inform, but claimant highlights and emphasizes that the only applicable law is the CISG, and there is no case of gap filling in our present case that would require another instrument to be interpreted and used in our present situation. But moving to the second requirement for exemption under Article 80, the counterparty is expected to overcome the situation by itself, or at least have reasonable attempts to overcome. Respondent did not try.
Excuse me, Counsel. I have a question regarding the UNIDROIT principles that you just mentioned. If I'm not mistaken, in the framework agreement, it is stated that the applicable law is the law of the Nubia, and the law of the Nubia mirrors the UNIDROIT principle, right? So in this case, both the UNIDROIT principle only applies to as a gap filling instrument, or is it it does apply to the claimant's obligation here?
An arbitrator, my answer is twofold. First, only the CISG applies and for all the parties' obligation, because the Nubia, Mediterranean, and Equatoriana, there is the place of business of the parties, are signatory states of the CISG, and is concerned an international sale, the CISG automatically applies. And the second point of my answer is that when it comes to gap filling, only would be required to a national law to apply if the CISG does not cover such issues and the national law covers. But we are dealing with an issue that is preempted and covered by the CISG, and because of that, to ensure the uniform application and interpretation of the CISG, it would be applied by itself. But moving to the second requirement, yes?
Excuse me, I don't know, were you still addressing Ms. Giri's question?
Yes,
Yes,
yes.
okay, sorry. So go ahead. I'll ask my question afterwards.
I'll already answer. I'm going to move to my second submission, please, Madam
Oh, so your
Arbitrator.
second submission. So in that case, okay, I would like to make a follow-up question. You mentioned that in this case, only the CISG applies. However, your colleague previously defended the position that the framework agreement, the arbitration clause in the framework agreement is the one that applies in this case. In that arbitration clause, if we go to paragraph 6 of Article 41 of the dispute resolution clause in the framework agreement, it states there that the contracts and any contract under the framework agreement are governed by the law of the Nubia. There is no reference to the CISG here. Of course, the CISG could be applied together with the law of the Nubia, but your submission appears to be that only the CISG applies here. Could you please clarify your submission on this point?
Madam Arbitrator, yes. First, when it comes to the law of the Nubia, I would like to bring Madam Arbitrator to page 66 of the case files that will have my answer. And please sign me when you're there.
Yes, I'm there.
This is the procedural order number 2, and on clarification number 38, I quote, "Is the CISG directly applicable in the Nubia, and is the Nubia an unitary state?" And the answer is yes. So first, the CISG automatically applies when it comes to international sales and the Danubian law is applicable. That is our present case. And because of that, there will be no need to rely on the national law of Danubia in order to ensure the uniform interpretation and application of the CISG.
But the fact of the matter remains that the CISG is not a universal contract law or universal sales law. Very clearly, the convention applies to certain aspects of sales law, and therefore there are a couple of issues where they have to be addressed. For example, how would one assess the cyber attack? It may not be deemed a fully sales law issue.
Mr. Arbitrator, Claimant does not contest that the CISG does not provide issues relating to cyber attacks. But when it comes to international sales, as it is our present case, the CISG applies. And our present case, what is related to cyber attacks, it comes to a duty to inform. And as already demonstrated, Claimant was not under a duty to inform. And also concluding the last premises of Article 80, Respondent will be fully able to overcome the email by itself, as it was fully of red flags on that email. Respondent never reached Claimant to ensure that it was a valid request, and Respondent ignored that in the framework agreement there was a requirement that all amendments should be in writing and signed by both parties. Especially when it comes to the bank account, there is the only obligation from the buyer and the parties when have altered the framework agreement concerning the bank account, it did fulfilling the requirements of signed letter of both parties. And Respondent cannot reduce its payment obligation. But if I may request an extra minute for this tribunal to conclude my submissions and demonstrate.
Of course, you can have the minute, yes.
Thank you very much, Mr. Arbitrator. Respondent cannot reduce its payment obligation. As already demonstrated, there was neither a causation from claimant's side or a breach of a duty that will lead respondent to the non-performance. And second, respondent was able and expected to have overcome the email by itself. Therefore, the parties does not share the responsibility concerning that. And even if respondent tries to rely on any other remedy, respondent shall not be able to do so, especially when it comes to Article 77 of the CISG. There is a specific remedy for damages, and therefore it's not applicable in our present case as we are talking about performance. With that, claimant restates its submission that first, it is fully entitled for the payment under the purchase order and the accepted goods, and second, respondent cannot reduce its payment obligation. Thank you.
Before we move, I have a question because I should have asked before, but I have been sort of internally debating with myself on the use of the word causation. Do you mean that the actions are attributable to one party? Is that the way you use the word causation?
If I understood your question correctly, Mr. Arbitrator, you're asking if there is a causation, if it can be only attributed to one party.
Yes.
Mr. Arbitrator, in the sense of Article 80, to have a causation, there must be attributed to two parties. The first must have had a breach, and the second, a non-performance. As in our present case, there was no breach from claimant's side, there is no causation that could lead respondent to its non-performance, as the mere start of a chain of causation is not sufficient to render an exemption of payment.
Okay.
Thank you.
So you, yes, because in some jurisdictions the word causation has a slightly different meaning. So Article 8 means is if the fail is caused or is attributed to one party. I mean, so effectively we are on the same wavelength. Thank you.
Excuse me, Mr. Presiding Arbitrator, can I ask an
Of
additional
course,
question?
of
Okay,
course,
thank
of
you.
course.
Yes, there is another relevant issue here that the arbitral tribunal must decide, which is the issue of modification of the framework agreement. I would like the claimant to develop on whether Article 7 of the framework agreement was modified by the 28 March email sent by Ms. Audi, or allegedly by Ms. Audi. So could you please develop whether there was a modification of Article 7 of the framework agreement, please?
Of course. Manner Arbitrator. First, when it comes to amendments of the framework agreement, claimant does not dispute that the parties had amended the framework agreement before, and among those times, they did not fulfill the requirements set forth in Article 40 of the framework agreement. That is, to have a written and signed letter by both parties. When it comes to an amendment of the bank account, the parties in 2020 had amended the bank account, and at that time, they fulfilled the requirements set forth in the Article 40, and not a written signed letters. Therefore, when it comes to the email from March that allegedly Ms. Audi sent to respondent, there could not be considered as a valid amendment for two main reasons. First, it was not sent by claimant and did not have its consent, neither after respondent receiving, because it did not reach claimant to communicate and ensure that it was from claimant itself. And second, it did not fulfill the requirements, and as the parties had amended the bank account, fulfilling the expectation would be that would be another amendment confirmed with the requirements set forth in the framework agreement, and therefore cannot be valid. Thank you.
Thank you, Counsel. I'm curious to hear respondent's view on this issue of the modification as well.
Okay. So any other questions, or we can proceed now to the respondents? Okay, I don't see anything further. So now the word goes back to the respondent for their submissions on this issue.
Thank you, Mr. Presiding Arbitrator, members of the Tribunal, opposing counsel, good afternoon. My name is Cristiane França, and I will address the issues of merits raised before this tribunal on behalf of Respondent, Visionic Ltd. In this arbitration, Claimant tries to evade the financial repercussions of the cybersecurity invasion in its system caused by its own employee. Now, by relying on its internal disruption, it seeks to leave Respondent with a large financial prejudice exceeding $38 million. And this is why Respondent has a main submission in the present case. Contrary to what was argued by the opposing counsel, Claimant is not entitled to receive any of the amount due under the Purchase Order 9601, only subsidiarily. In the remote hypothesis that this tribunal considers the Respondent also contributed to the lack of performance, the amount that Claimant should receive must be limited to the minimum parts of the amount due under the Purchase Order. The members of the tribunal addressing the concern of Madam Arbitrator, in the present case, Respondent will not try to argue that there was a valid amendment to the framework agreement. It only respectfully requests this tribunal not to allow Claimant to invoke the formalities established under Article 40 of the framework agreement when the parties have deviated expressly from such provisions, not only once, twice, nor thrice, but at least 6 times before. So this arbitral tribunal shall not allow claimants to preclude the compliance with these provisions only when it's relevant to claimant, and in other circumstances not to apply them. But members of the tribunal, here we're facing the fact that Respondent should be considered as exempted from performing another payment. And this is because by virtue of Article 80 of the CISG. Members of the tribunal, Article 80 provides that a party is excused from allegations of non-performance if the failure is a consequence of an action or omission of the other party. And in this sense, according to Professor Franco Ferrari, which is Professor of Transnational Litigation, Arbitration, and Commercial Law at NYU, 2 elements are necessary in order for such provision to apply. Firstly, there needs to be an action or omission attributable to the invoking party, and second, a causal link between such act or omission and the non-performance. And Respondent will now demonstrate before this arbitral tribunal that both elements are met in this case. Firstly, because Claimant violated a duty to inform in the present case, which constitutes an omission in terms of Article 80 of the CISG, and second, by not disclosing about this cyber attack, it created avoidable risk to Respondent, and therefore a causal link between its omission and Respondent's lack of payment. Now, members of the tribunal, according to Professor Schwenzer, one of the main authorities on the application of the CISG and a former member of its advisory council, an omission is constituted in terms of Article 80 if an act was necessary and suited to enable performance of a contract. And this is exactly the case at hand. In the present dispute, the cyber attack on Claimant's system was entirely caused by Ms. Aldi, which was a high-ranking employee of Claimant at the time of the incident. In order to demonstrate so, I will kindly ask the tribunal to please follow me to page 61 of the case file, please. Is the tribunal with me? Thank you very much. Members of the tribunal, this is the procedural order number 2, and if I can direct this tribunal's attention to paragraph 5, which asks, and here I quote, "What were the exact circumstances of Ms. Aldi's departure from Censor Acts?" End of quote. If I can direct this tribunal's attention to the 3rd line from the top to bottom, starting with her clicking, and here I quote, "Her clicking on and download of the discount code for the car race was a clear violation, not only of Claimant's cybersecurity guidelines, but also of the prohibition to use the computer for private matters." End of quote. Members of the tribunal, here we have the fact that the cybersecurity that Claimant uses to try to avoid the financial repercussions of its own actions was caused by its own employee and therefore is attributable to Claimant. And in that circumstance, when the cyber attack was discovered on January 23, 2022, and even after acknowledging that the data of some partners had been compromised, Claimant chose not to notify respondents about the incident. There is a case from the Estonian Supreme Court which is very much similar to the present case. In that opportunity, the parties, they have signed an international contract for the sale of chicken meat. However, after the due date of payment, the seller discovered that it didn't receive any payment from the buyer, and later the parties found out that in fact the buyer had received a phishing email requesting that the payment would be made to a different account. In that opportunity, it wasn't possible to apply Article 80 of the CSG because it was not possible to determine whether the cyber attack could be attributable to the buyer or to the seller. As a contrast, in the present case, we do know as a fact that the cyber attack was a result of Ms. Aldi's own actions and therefore attributable to Claimant. Consequently,
Excuse me, Counsel, if I may, I have a question. Because for me, it's not clear if you can find an answer in the case files on the causal link between the cyber attack and the email sent by Ms. Audi. Can we be sure that the email was sent due to the cyber attack?
Madam Arbitrator, it is respondent submission in the present case that this could be established by virtue of the fact that the information contained in the email was highly specific and also confidential, meaning that only Ms. Audi herself had access to such information. So it wouldn't be possible to, in fact, have access to these details otherwise from her computer, which was exactly the case in the present proceedings.
Okay, but there is no evidence, just to be sure, there is no evidence in the case files that it was due to the cyber attack that this email was sent. It could have been any other issues related to this email?
Madam Arbitrator, there is no such a specific information. However, the cyber attack, it happened on Claimant system, and a whole set of the data from Claimant was ransomed by the cyber criminals. So in that specific opportunity was in fact the moment after Ms. Audi clicked on the link that allowed the Trojan horse to enter into Claimant system, that in fact the hacker that used the information acquired it. So in that specific way, looking specifically at the circumstances of the email and of the cybersecurity invasion, it would be possible to establish that in fact it was a result of Ms. Audi's own actions. And consequently, by not disclosing about the cyber attack, Claimant did not comply with its duty to inform, and respondent will demonstrate so in two parts. Firstly, because contrary to what was argued by the opposing counsel, respondent will not rely on provisions of the CISG, but rather on the application of the UNITROS principles on international commercial contracts, because those principles are binding on the parties in the present case, and they do impose a duty to inform. First of all, members of the tribunal, it is respondent's conviction not only that the UNITROS principles are applicable, but that they are binding on the parties in the present case. And this is because those principles, they are recognized as international trade usage. And according with Article 9, Paragraph 2nd of the CISG, it establishes that the parties are bound by trade usages, even in the absence of an express agreement in this regard, given that this consists of international trade usage that is widely known and regularly observed. And this is specifically the case when it comes to the UNITROS principles. For instance, there is a decision from the Russian International Arbitration Court in which the contract that was being discussed on that opportunity was governed by the CISG, and the court decided also to resort.
I'm a bit unclear here because you seem to imply trade usages between the parties, having also indicated earlier at the beginning of your submission that there have been no less than 6 modifications to the contract. So the establishment of any practice between the parties might be very controversial. and not on the unilateral principles as the law of the national law of the related countries to the contract.
Mr. Presiding Arbitrator, the unilateral principles in this specific circumstance could be applied both ways. As consistent of international trade usage, which is recognized as having such status on the decisions of several cases from courts and tribunals, and also as a contractual law of Danubia, because as correctly provided and pointed out by Madam Arbitrator, it does apply to the framework agreement. So it could be also applicable in this case. And in fact, Article 513 of the unilateral principles, they do establish a duty to cooperate. And here I quote, "Each party shall cooperate with the other party when such cooperation may reasonably be expected for the performance of the party's obligations," end quote. Likewise, Article 1.7 establishes that the parties have to act in their conduct in accordance with the good faith principle and according to the fair dealing international trade, and such provisions cannot be derogated. But here, members of the tribunal, we have the unilateral's commentary to such principles, and it provides that when combined, they do establish a duty to inform. And such duty to inform is specifically relevant when it comes to long-term contractual relationships, such as a framework agreement, because given the context in which the parties they are cooperating for a long term, it is even more relevant for the parties to provide information one another to the performance of the contract. And even if the tribunal would not be satisfied as to the existence of an objectively established link between claimant's omission and respondent's lack of payment, in accordance with Professor Thomas Newman, that has specific studies on Article 80, an indirect causation would be sufficient in cases in which there was an assumed risk that falls within the sphere of action of the invoking party. And this is exactly the case in the present proceedings. But in the remote hypothesis that this tribunal understands that somehow respondent has also contributed to the lack of performance, then this tribunal should limit the amounts that claimant should receive to the minimum parts of it. And this is because, contrary to what was raised by the opposing counsel, respondent will not try to rely on Article 77 of the CISG, but rather, according to Professor Peter Schlatrium, which was member of the commission that drafted the CISG himself, this provision contains an idea of apportionment. But this apportionment needs to be made proportionally to the weight of contribution of each party's conduct to the lack of performance. And here, members of the tribunal, respondent submits that claimant's conduct should be deemed way more aggravating than respondent in the present case. Because firstly, if claimant had at least informed respondent that it didn't receive the first payment, certainly respondent would have made the second one. And lastly, because claimant was not only negligent towards the international principles, the provisions under the framework agreement, but also towards its own personal, because respondent was left for more than 126 days without a corresponding accounting manager on claimant's side. And this exceeds any reasonable acceptance of the fact that claimant was facing a cybersecurity incident, because it consists of a multi-billionaire company that needs to assure that it has personnel and that its system functions properly to develop its activities. And this concludes respondent's submission, if I may not be of any further assistance.
I would like to ask, to have a sort of a question or reflection perhaps on your last point, because that came very much from Peter Slechten's apportionment issue. And I wonder whether the real issue under the CISG is the risk that parties assume in a sales contract. So, and whether a particular risk, cyber risk or others, cyber attack, is in the risk of one party or the other. I mean, obviously, it's not attributable to the parties, and an attack is an external event in most cases. But the sort of the safeguards, the security protocols that software and computer systems have is a matter of risk of either the claimant or the buyer. And I wonder whether that is also what the real issue that one can read if one reads the words of Peter Schlechter on the apportionment.
I'm sorry, Mr. Presiding Arbitrator. Could you please rephrase your question?
Of course.
Thank you very much.
I'm asking you on the basis of the last quote you had from Peter Slechten, that the CST works very much on the apportionment. And I wonder whether the real issue here is on whose party's risk an incident occurs. So is on the seller side, on the buyer side, irrespective of whether the seller or the buyer is themselves responsible for the problem. So isn't that the if you wish, the blind justice argument of who bears the risk of compliance or non-compliance?
Mr. Presiding Arbitrator, Respondent respectfully disagrees. Because in the present case, what needs to be taken into consideration was that claimant's omission did in fact impair respondent's possibility and to in fact perform its main obligation under the contract. So when it chose not to make sure that any information on the cyber incident actually reached respondent, it assumed the risk of any prejudice that this omission would result in. This answers Mr. Presiding Arbitrator's question.
Yes, it does. Thank you.
Thank you very much.
Council, if I may ask you like a sort of related question. When you were dealing with this issue, you cited, for example, a case that dealt with some sort of similar fact regarding a phishing attack in which different bank account details were provided. I understand also that around the time that this happened, there was a lot of publicity in the industry regarding the fact that this kind of phishing attacks were happening very frequently. You also mentioned that the payment obligation was the main obligation of the purchaser here, because it was purchasing something, so that like you're paying, that's your main obligation. And we have a situation in which in the past, when the parties had made changes to the payment obligation, they had complied with all of the formalities of the framework agreement. In particular, like they had a signed agreement indicating where the payment should be made. In light of all of this, like what is your position about respondents' here duty to have being more cautious in terms of having made a significant payment, as you yourself mentioned, about like almost $40 million to an account that is not an account stipulated by the parties in writing, but just based on an email communication?
Madam Arbitrator, thank you for your question, because this allows respondent to clarify a few important points. Firstly, we do not contest that the payment is respondent's main obligation under the contract. What we do submit here is the fact that by omitting such relevant and important, rather a fundamental information for respondent to perform the correct payment, claimant itself jeopardize respondent's main obligation under the contract. The incorrect payment was not a result of respondent's conduct, but rather of claimant. And further, in the present case, respondent did not lack due diligence. Because contrary to what was argued by the opposing counsel, when respondent received the email from the hacker, it stated on the last line that Ms. Audi was out of office due to sickness complications. In fact, Mr. Royce did try to reach Ms. Audi. However, the voicemail stated exactly what was on the last line. So in that point, in that circumstance, given the fact that all the information contained in the email was highly specific and that only the parties could have access to, and the voicemail confirmed such information, and the parties had a long-term relationship, respondent In fact, after exhausting what would be necessary to confirm such information, proceeded to the payment, but as a result of claimant's submission.
Thank you, counsel.
Thank you. If there are no more questions, then we can return to the claimants for any rebuttal they might have.
Members of this tribunal, my opposing counsel just brought that respondent Ms. Royce tried to reach Ms. Aldi by phone call, and on her voicemail, it stated that she could reach and was required to reach for urgent matters another person in claimant's side, another point of contact. The only fundamental information here that respondent needed was provided in the framework agreement, and its lack of payment was to its own lack of care. And because of that, respondent shall pay again. Thank you.
Thank you. Any rebuttal?
Members of the tribunal, claimants in the present case took more than 4 months to give notice of the lack of payment, rather on the fact that they didn't receive payment from respondent. Respondent was left for 126 days without an account manager on claimant side. And in fact, even if respondent contacted Ms. Joanne, which was allegedly replacing Ms. Aldi, she would still not be possible to be reached because she was in the hospital by virtue of pregnancy complications. So this tribunal should not allow claimants to get away with its reckless actions and by virtue of its own internal disruption.
Thank you very much. So, unless there are any more questions from my co-arbitrators, I would like to thank both parties for the submissions. They've been very helpful, make our task a bit more complicated than we have liked to. It's not a very clear-cut case. And I would like, for the record also, to ask whether the both parties are satisfied with the way we conducted the hearing so far today.
Yes, Mr. Presiding Arbitrator. Claimant is satisfied.
Respondent is also satisfied, Mr. Presiding Arbitrator.
Thank you.
Thank you very much.
With your permission, we will then move to our deliberation room, and we'll be back as soon as practicable, but within, I would assume, next 10 minutes or 15 minutes maximum. Okay, thank you.
Thank you very much.
So, hi everyone. Just a few words before we announce the winner of the Souto Correa Pre-Moot. I began my career participating in the Vismut 15 years ago, so I know how much effort one needs to put in to arrive where you are right now. So congratulations to both teams for making it to the finals of our Pre-Moot. So I thank, in the name of Souto Correa, the ICC for their support to this event and also for hosting the final panel of the Pre-Moot. Congratulations for all the teams actually that participated in our Pre-Moot. It's a pleasure for us to organize this event, and we really hope to see you in our next edition next year. And thank you also for all the IT team that is here supporting us on this Sunday in São Paulo. Thank you very much for making this event happen. And then, Lucas, please, you have the floor for the announcement.
Thank you, Laura. First of all, it has been a pleasure for me sitting with Michelle and Laura. We have heard two very sophisticated and sort of well-developed arguments. And this is particularly impressive given that you have almost another 5 or 6 weeks to Vienna. So I know that sort of the mood dominates quite a bit of one's life. It's getting sort of longer and longer. We were very, very impressed by both presentations and by all four advocates. And I recalled a case which is I have done many years ago, where there was a slightly similar topic, sort of sophisticated sort of technology and cyber attacks, but a case where payments are going to the wrong direction rather than the direction of where the parties have intended in their contract. And at that case, one party was very well represented, but the other party was represented by a local lawyer who was not very helpful. So the arguments we have had here today were very, very helpful, but also very difficult in the sense that we were very, very close. And making a decision came back to small details, very, very small details. But I would like to, but we have to make a decision. And I have to congratulate all of you for your engagement and excellent advocacy skills, very good knowledge of the subject matter, and very good preparation. But as I say, with a very narrow margin, we find that UFPA prevailed today in the arguments. You don't have to give an acceptance speech, but if you wish, the floor is yours.
Well, we would like to thank you all for arbitrating the panel. We are extremely glad for the opportunity. We'd also like to thank the other team for the opportunity of completing with you. Just thank you all. That's it.
It's an honor to be present here in this panel with such great specialists. Thank you very much for the opportunity. And congrats to the other team as well for reaching the finals.
Of course, I mean, you're both very, very close. I mean, congratulations to you, both teams indeed. And the whole support team of you have in the back, so that your other team members, etc.
Yes, congratulations. Parabéns. Parabéns, Luiz.
Muito obrigada.
Thank you. Muito obrigado.
Yes, congratulations to both teams. It was a tough decision for the tribunal. And also, again, I would like to thank Michelle and Professor Lucas for their participation and for being here with us on a Sunday afternoon. Thank you very much. Congratulations to both teams. We wish you all the best in Vienna. And that's it. Thank you all.
Thank you.